Thank you very much for inviting me. I'm very honored, and as you will see, the presentations very nicely fit into each other, which you would guess it's because of the great coordination efforts we did among ourselves, which is not the case. So it all goes to Lionel, who did a fantastic job in explaining what we should be talking about. So he's the person to thank for that. So my part of the job is to talk about the intellectual property in the EU Charter and how it interfaces with what was told and what the EU Charter is doing, and how what is happening there is different and why it matters. So this will be subject of my talk. So before I get there, I'd like to say something about IP as a protected value. So you've heard that there are a couple of human rights instruments that protect IP as some form of value, and either in a form of recognizing that if a state recognizes as a property, you then consequently protect it in the human rights instrument as a possession, or because they are embodying some guarantee for the states to maybe create some regime where not necessarily IP is created, but some sort of attribution of value goes back to the creators. Interesting and important thing is that the system is composed of several layers, and you have international layer that we've heard about. We have on top a trade law level, and we also have, of course, when we go down to the regional level, we have a regional level, and further below we have a domestic level, and they interestingly interact. And I think once you get to the regional level, you suddenly see different interactions that you have saw on international. I'll try to make point what's happening there. In the EU in particular, and this is what I'd like to be, one of the messages is that in the EU, since we introduced the Charter, when we started protecting IP explicitly in the Charter, the role of that clause has changed, and the way it shapes the law has changed compared to what the international treaties are doing. And I try to illustrate that shift. And then, and one of the last points that I'll be making is that a Court of Justice is very active in using the clause to devise different, to achieve certain purposes, apart from other things, harmonization, but also to some extent, the strengthening of IP rights in certain cases. Okay, so first, this is what we have heard so far. So we have European Convention on Human Rights, and we have the Article 1 Protocol, which guarantees that possessions are protected. And as we have heard, a very important thing there is that it's always referenced back to the domestic law, which creates the expectation of possession. We have Universal Declaration of Human Rights in Article 27, where it's paragraph 1, which is about cultural participation, paragraph 2, which is about the rights of authors and creators. And then we have Covenant, which is reflecting this Universal Declaration. And of course, we have a regional level, the EU, and then we have national constitutions. And national constitutions sometimes, and this is why I have it here, they sometimes take the model of the ECHR, so more sort of a property model, just protecting it as a property in the property clause by saying, well, when the state creates it has to somehow equip the particular property. Or sometimes they take the Universal Declaration of Human Rights model, so in addition, next to the property, so they also have this guarantee, explicit guarantee, which very often just copy and paste everyone has a right to protection of moral and material interests resulting from, etc., etc. So one of the examples, for instance, is Slovakia, which has basically this language taken from the Covenant and Declaration explicitly in the Constitution, and at the same time also has the property guarantee. And we also see mixed systems where you have only property clause, like Germany, but nevertheless the court recognizes there is some institutional guarantee in the property clause that guarantees that some form of protection for certain achievements has to be devised. So there is also this kind of a positive undertaking inside of the property clause. Now, important thing about the convention is that because it refers mostly to the domestic law, the convention doesn't make some additional promises on top of what the domestic law doesn't do. So it basically says pretty much the old idea: stick to the promises that you have made, and if you'd like to interfere with those promises, try to justify that. But the problem of that is, of course, as Henning has very nicely illustrated on this Dutch case, is that you try to define what the promise is by reference to domestic situation, and then you try, with the hindsight of domestic situation, assess whether compulsory licensing is a part of the design or is rather an interference with the design, which is the body of IP right. And that's a very tricky part for the regional body, which doesn't have any domestic layer of how IP law looks like. Of course, there is international public law, but that's a completely different branch of law. So it's a hard job to do for the region, for these kind of international bodies. So that's why the result of this is a very broad margin of appreciation. So, and I think a very nice example of this is one of the latest cases, this Latvian case, SIA AKA versus Latvia, where a court had to assess a situation where a collecting society was denied injunctive relief repeatedly in a copyright scenario. And the court had to assess whether that's compatible with the guarantee of Article 1 of the Protocol 1. And the court said, well, the margin of appreciation is rather broad, so we're willing to accept this as the outcome, although you could question whether that's compatible with the EU law, whether that's compatible even beyond with international public law. But because of this setup where you don't have insight of how IP laws look like, the margin of appreciation is broad, and it also depends on what is the design of domestic laws. Now, of course, apart from this consequentially stick to the promise that you make, we also have this do something about creating the rights of authors. And this is what was already discussed with respect to the Covenant and the Universal Declaration, in particular the Article 27.2 and the Article 15.1c of the Covenant, which are saying that you have to make sure that everyone has the right to protection of a moral and material interests resulting from those kind of creative pursuits. Now, what does that really mean? And in the literature, we have suggestions that this should mean that there is a modest obligation to make sure that economic exploitation of these results somehow flows back to the authors. We don't know how far that really goes. We have, of course, what we have heard, we have general comment, which is not completely authoritative on the issue. But one of the takeaways that we can, although we don't know the full scope, what we can take from this is that this obligation cannot be equated with an obligation to institute an IP system. It's an obligation that says that the people who create and engage in these creative pursuits have to benefit from it back, but how far does it go, we don't really know. And that guarantee can actually be used even against a deformed IP system, which doesn't benefit those people who create. So it's an obligation that is really independent in its reach. And you can see one of the examples where the National Constitutional Court is actually reading this kind of clause and recognizing that the idea of this obligation is really try to achieve that the flow of value goes back to the creators, but it doesn't mean that the copyright system, for instance, for the authors is the only way how you achieve that. So that's what we have on the international level. Now, EU Charter has caused a big shift in this because EU Charter is introduced in a regional system which has a big insight of how IP laws look like. Why? Because there are tons of directives, regulations defining how IP laws look like, how remedies look like, how exceptions look like, etc. And this, naturally, I mean, you would expect that causes that the margin of appreciation will shrink. And it did. And this is what we indeed see. Now, but before I get there, before we had the EU Charter, we also had some principles that were embodying the IP value as a part of the generally protected values, which we had to sort of solve this disbalance where the union law didn't have an explicit human rights instrument, so we had to sort of invent something by court. And the court invented this in its early case law relating to the free movement of goods and services, and I'll get there in a second. But even with respect of these general principles and also with respect to the Charter, one thing that has to be kept in mind, unlike these international obligations. And unlike the European obligation stemming from the European Convention of Human Rights, the Charter doesn't apply in all domestic situations. It applies only in a particular set of domestic situations. And that is mostly, as Article 51 is saying, when the European law is implemented. And the most typical and easy situation is where domestic law implements the directive, or it's an application of a regulation in a domestic setting. So that's then obvious, then a union law is implemented. But that's not the whole story. We also have the Charter applying in the context of non-harmonized domestic laws that somehow end up being in under the radar of the union law. And that is most of the time primary law. So you end up having a domestic IP law that is not being harmonized, so publishers' rights against aggregators, and that is questioned from the perspective of the free movement of goods and services. And when Court of Justice does that assessment, it has to also take into account the IP background behind this, and there it has a human rights obligation to actually assess the scope. So it has sort of two obligations in one, which is a long-standing case law that sort of precedes the EU Charter. Now, of course, this is not the only provision that is somehow close to IP. We also have this famous or infamous, depends on perspective, right to conduct business, which is sort of taking lead in many cases. You see that discussed by the court. And we have a right to effective remedy, which I'll suggest that is actually very important. Now, the clause itself, as you know, is not very remarkable, right? Intellectual property shall be protected. That sounds pretty much something like of a technical equivalent of saying Italian food shall be tasty. So it doesn't really say much. And as Henning said, well, it's difficult to assess what that really is saying. And so I think the main thing why we don't know what it's saying is because we don't know how it should be protected and from when it should be protected. And I think so those are two, academics will also like to know why it should be protected, but at least these two answers probably tell you how far the guarantee really stretches. So let's search for the meaning. And in the literature, there was discussion, what does this really mean? And Christoph Geiger's article is one of the articles exploring this. And pretty much his conclusion is the clause should be nothing more than simple clarification that Article 17.1 guarantee also applies to intellectual property. In other words, they shouldn't do much. It should be basically just a restatement what a protocol was already doing, just in the European context. Because in a way, the reason why we had a charter, also with updated level of fundamental rights, was in a way to sort of take away from the pressure that we might be somehow later reassessed by the ACHR in our assessment. So this is a sort of agreement. That agreement was in the literature before we got to the first cases, and I would suggest that this is not what we see today. And there are some. And another example, for instance, is from Professor Griffiths, who was saying, well, it certainly doesn't guarantee protection where none is currently enjoyed, which is, I think, even still the case. Or, for instance, it also does not require introduction of a specific form of enforcement mechanism, which does not exist. And this part I'll try to challenge because I think that's not what the Article 17 is doing. So at the moment, I think, and this is what we see being recognized, for instance, Milley is one of the authors, is that 17.2 is taking on itself a different role than the protocol was serving. And the reason for that is really proximity and a hindsight of how IP laws look like in the union system. So the 17.2 is now assuming roles that didn't exist under the protocol. And this is what I consider very important. We've heard about this, that fundamental rights guarantees are not only about the safeguard against the state not to interfere, so negative undertaking, but we also have a positive undertaking of creating some particular environment, equipping the right with effective means, how it gets enforced, etc. So it's more outcome-oriented. And I will suggest that we actually see this happening where court, in its case law about enforcement, is actually taking additional step, and even in a situation where secondary law does not explicitly provide for this particular type of measure, and the measure is not even in a TRIPS, so it's not like a standard of the international law, the court takes steps and suggests that this remedy has to be provided because that's the effective remedy that needs to equip the article, needs to equip intellectual property in that particular setting. And maybe I could already unpack this here. What I'm explicitly referring to is a case law shift from Pro Musica to Code Germany, where basically in Pro Musica, the Court of Justice, before the Charter entered the picture, said, well, and the Spanish court was asking, do you have to have a disclosure from internet access provider? And the court said, no, you don't, as a matter of secondary union law, but if you do, then you have to balance. Why? Because there was, as I said, the typical doctrine of derogations have to be also screened for human rights obligations, interferences. Now, suddenly in the Code Germany, which was concerning a bank and disclosure, so even more sensitive, and is a post-charter, the court comes to the conclusion that actually German provision, which in general prohibits disclosure, it's against Article 17.2 guarantee and Article 47 guarantee, which is the right to effective remedy. So you see that shift where basically there was a clear idea, I would suggest, of what a secondary law is, and the court is taking that to the next level, and its argument is not about secondary law, but it's about underlying charter. So he's suggesting that effective remedy has to have something more than just try to shape the secondary law as it exists, and actually has something to say about how it should look like. Now, I would suggest that these conflicts or situations of conflicts are the cases where actually we see how court is approaching Article 17.2 the best. So from the wording, we really cannot distill anything. And it's in the cases, it's in the conflictual situation that we can see what the court thinks of what the role of the provision should be. Now, very interesting feature is that if you look and try to compare how court is resolving conflicts in a situation between Article 17.2 and other fundamental rights versus how it used to resolve cases of free movement of goods and services versus IP rights, domestic IP rights, the way that conflict is resolved is very different. The margin, the analysis, what you believe is the political sort of a basis is very different. And because of that, we see now sort of more intensified conflict resolution where court is becoming more prescriptive as a result of the analysis. And I think Professor Griffiths will probably talk about that a little bit more. The reason for that could be because in the free movement context, IP was in a defensive role. So you had this national IP system which was encroaching upon free movement of goods and services, and you had to justify that system against free movement of goods and services. So you had to say, well, this is all necessary to have this particular value transfer incentive scheme or whatever. And suddenly here you are in a different position, and plus you're not talking very often about domestic law versus primary law, but you're talking very often about two situations where secondary law of the union backs up the two. And the court loosens up the constraints and the conflict resolution usually when it comes to the secondary law because of political reasons, obviously. Now, despite this sort of a fragmented way how the court approaches the conflicts, what we see is that that there are some principles that are sort of carried from the times before the Charter to today. So one of the principles is the social function of property, so something that was mentioned. The court has recognized it before the Article 17.2 existed. Metronome music case is a fantastic case where the court explicitly, even more explicitly than in Luxan, says that there is a social function behind why we actually give this particular rights. And that social function is something we have to consider also when we construe what 17.2 should be providing. I would really encourage you all to have a look at Metronome music case. It's an old case, in 1998, but it's an interesting case because the German court is asking whether the Rental Rights Directive is compatible with the free movement of goods and services and the IP and the right to conduct business. So the court is sort of taken to the position to defend its union law from the perspective of fundamental rights, which doesn't happen that often. There are very few cases of this kind and usually not very serious. Now, another principle that we see is that, which is sort of very often repeated these days, is that 17.2 doesn't offer any absolute protection, right? So this is became very popular from Sabam, but actually it again comes already from pre-charter case law. Metronome Music already said that it's no absolute protection. It's a protection that has to be measured against other conflicting values, whether that's a fundamental right or a public interest, and it has a particular social function in it. Now, what we see, one of the things that we see after the introduction of the EU Charter is that we see inflation of case law that is trying to resolve things as fundamental rights, sort of tries to frame conflict as a fundamental rights conflict. So even in situations where construction of a secondary law would be just enough, the court goes a step beyond and tries to discuss it on the level of one fundamental rights against another. And this is not just IP issue. It's a recurring problem in union law in general, and members of the Court of Justice are aware of that, that they are overusing it to a certain extent. They're discussing it, but they're still overusing it. So there is no much change from there. But one of the things that I'd like to say why this is important, and it's not just a matter of methodology, is because by suggesting that something flows from the level of the Charter, you're suggesting that the legislator cannot legislate it away so simply. And that is a petrifying effect that you can have if you do a sloppy analysis on a different policy level. So it's a kind of very important thing to consider. And this is what I already mentioned. Now, towards the end of my presentation, I'd like to give you the structure to think about how 17.2 conflicts with other fundamental rights. And then there should be a natural bridge to the methodology part. 72, of course, pops up in a very different situations, and IP is sort of a very structured system where we go from ownership, subject matter, scope of rights exceptions to remedies. And we see that these cases of conflict are popping up mostly so far on the level of remedies. By far, most of these cases are there. And interestingly, it's internet case law that is driving most of these cases. So those are the cases whether rejecting injunction is something that is okay or not, whether having disclosure or not having disclosure against particular innocent third party is okay, etc. So we have many of these cases there. We have also some cases on the level of exceptions. So Beckman case is a typical example, right? Freedom of expression and a parody exception in the copyright and the balancing of the two. But there can be many more exceptions. So you can think about a right to pursue research and an exception in patent law and many different other exceptions. On the level of the scope of the rights, we have more construing potentially of exclusive rights within in the light of fundamental rights, and we have some case law from the past actually that was trying to do that, and we can see how court could maybe behave from the free movement case law, where the court was doing that, for instance, construing a distribution right in light of a free movement of goods and services. So, but we see today even that the scope of the rights can actually can sort of stumble upon fundamental rights. Think of hyperlinking case law, which can very easily, in some situations, have issue with freedom of expression in case you receive a knowledge and actually consciously link to something, and hence there is a copyright relevant act for which there might be no exception, and there might be a problem with the freedom of expression. Now, on the subject matter level, that's sort of very down. Usually, we don't have that many cases that would suggest that there is a conflict there. But for instance, there are cases which we're trying to suggest that daily news are exempted from copyright exactly for the reason that a freedom of expression has to be guaranteed. So sort of like an inbuilt design choice within the copyright system is imposed by the external tool, which is freedom of expression, to make sure that that is there. And the last type of conflicts is what you see today, and I would suggest that the plain packaging cases are there, are cases where you have a certain value and you have a certain ownership over those things, and you're trying to sort of use that ownership to imply that you also have a right to actually exploit that economic value on the market, and the state is more regulating the use of that particular value than how you actually have your IP right designed. So those are different type of cases, and we have more of those popping up in trademark law, and probably will be happening more often that IP law would be instrumentalized for these purposes. Now, the last point about 17.2 and the domestic level. Now, the union level, of course, is very influential in framing and creating some particular outcomes. And it influences the analysis on domestic level. But unsurprisingly, in many continental countries, you still use your own domestic reference point. So you don't discuss things very often as Article 17 Charter issues, unless it's, for instance, regulation context. But you discuss your own domestic constitution and its guarantees. You try to give it a meaning and construe it maybe in the light, so sort of to avoid a conflict, but you still use your domestic reference point. And this is happening in Germany with the cases that Martin Husovec will talk about. This is happening in Slovakia. It's happening in many other countries that you still use the domestic reference points, just try to internalize the outcomes. Interestingly, I don't know what will be the case in the United Kingdom, because it seems to me that the reference point is what is being used is often the charter or the protocol. I don't know what happens if the two will vanish at some point. What will be we discussed yesterday whether Magna Carta would be the reference point. I kind of wonder. That's an interesting question for you. So to sum up, basically we're still on the road of trying to sort of outline what Article 17.2 really means. There's a lot of shift, and the scrutiny is tight. The court is becoming more prescriptive, exactly because of the hindsight. I would suggest that it's even creating a positive obligations of a certain kind, but still it rests and recognizes basic principles that no absolute protection is offered. Grant of the rights has to serve a certain social function. There might be a countervailing right to participate in a culture, in some countries even explicitly, which you could subsume onto the social function. And basically IP is always subject to limitations of other fundamental rights. And once it's get there, the question is how the court resolves the conflicts. And this is what I would leave to Professor Griffiths to discuss. Quickly, here you have some suggestions if you're interested in this that you might want to have a look at. You recognize that many people who are here will be mentioned there because they're leading scholars on the issue. Okay, thank you very much for your attention, and look forward to your questions.